Hello. Well, good afternoon if you're on the East Coast, and good morning if you're way out west. My name is Aaron Lacey, and you are listening to Responding to Student Borrower Defense to Repayment Claims 2023 edition. And the reason it says 2023 edition is because Thompson Coburn is part of our higher education webinar series. We actually did a webinar on this same topic a little over a year ago, but there's been enough change since then that we thought it would be prudent to go ahead and do another round and talk about this topic once more. So we're glad that you all are with us here today. While folks are still joining, I'll go ahead and jump through some of the housekeeping. First of all, if you have any questions during the webcast, as is typical for our webcast, you can submit them at through the Q&A widget throughout, and then we will try to get to the questions at the end. A copy of today's slide deck is available in the resource widget at the bottom of your screen, and we encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical questions located in the help widget. You can find answers to some common technical issues located in the help widget at the bottom of your screen. As far as CLE, if you're an attorney type and you are joining us for continuing legal education credit today, this webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general CLE, and in Missouri for 1.2 hours of general CLE. The webinar is also CLE accredited in New York for 1 hour of experienced and transition credit. We award CLE based on attendance for the entire 60 minutes, so please do tune in and be aware that we will display a couple of secret words in multiple choice polls during the webinar, and you'll be required to select today's secret word from a multiple choice list. Beforehand, I was chatting with our producer. I was a participant in a webinar just 2 days ago and missed the second secret word. So please make sure that you're paying attention and you click the radio buttons when the secret words pop up. And then finally, at the end of the webinar, there will be a post-webinar survey. We are deeply appreciative to those who take a few minutes to fill out the surveys. We always read them, and we always try to take that feedback and use it to make the next webinar better than the one before. Thompson Coburn, if you're not familiar with us, we're a law firm. Everyone who's presenting today is an attorney. We have nationwide over 400 attorneys, so we're a fairly large firm spread out around the country, headquartered in the Midwest here in St. Louis, but with offices in places like Washington, D.C. and Los Angeles. And we have a higher education practice, meaning that we have a group of attorneys in our law firm who spend all or most of their time thinking about higher education and working for and supporting institutions of higher education. Today's presenters, first and foremost, I'm delighted to introduce one of our usual suspects, Scott Goldschmidt, former Deputy General Counsel at Catholic University in DC, brings a decade of in-house experience and then plenty of time as a private practice attorney as well, routinely works with institutions of higher education. And Scott is currently leading our BDR response team. There is enough activity in this space that we have a team of individuals inside the higher ed practice that are really working closely with institutions of higher education. And I said leading, but to be fair, Scott is co-leading the team with my other partner, Jeff Fink, who is one of our litigation partners, but spends a lot of time working on matters with institutions of higher education. Jeff in particular has done a great deal of work in managing program review responses with the U.S. Department of Education and other sort of agency matters where you have an institution that may be having some trouble with an accreditor or with a state approving agency or any other one of those agencies that tends to regulate institutions of higher education in particular. So Scott and Jeff, very grateful as always for you being here today and for all the work you guys have been doing on BDR responses and for sharing that with folks today. I mentioned my name's Aaron Lacey. I'm the chair of the higher education practice here at Thompson Coburn and do a lot of different things for institutions of higher ed, but I think it's fair to say my sort of core focus is on federal higher education policy and regulation. And so I spend a lot of time thinking about what's going on to the U.S. Department of Education. And if you're a regular attendee to our webinars, trying to communicate some of that out to the broader higher ed community. Here's our syllabus. We're going to start with a BDR rulemaking review. And this is not just a throwaway, here's the history of the thing kind of section. I mean, we really want to talk a little bit about what has proceeded, and also the Fifth Circuit litigation and the suite litigation. If you've had any exposure thus far to borrower defense, or you've spent some time thinking about it, you probably know that it is a very dynamic space to be in. Dynamic is probably a generous word, and another way of saying it's a very muddled space to be in, because we've got two different lawsuits that are having a real impact on what is currently being enforced and what is not being enforced. And then you've got multiple generations of this rule. So it's complicated, to say the least. And we felt like we needed to start out the presentation with trying to explain where some of that is, and to try to give you all some context as to what the department is doing right now and which rules are in play and how that might change based on where the litigation is. So I'm going to start out over the first 20 minutes here talking about the rulemaking. I'm going to talk about claim volume and the suite settlement and the current BDR frameworks. My goal is to get through all of that in about 20 minutes. And keep in mind, you've got the slides. This was recorded and it's free. You can go back and watch these webinars at your convenience. So it is complicated. If it seems to be a little overwhelming, please feel free to take time and go back after the fact. And then we have some written materials as well, I'll point out at the end, that summarize some of these things. So you've got the slides, the written materials, and the recording of the webinar. So you don't have to internalize it all in real time. But then we want to save at least 35, 40 minutes of the presentation for Jeff and Scott. And we're going to switch into sort of a Q&A format. I'm going to put on my moderator hat and take off the lecturer hat and pose some questions to Jeff and Scott, and ask them to respond based on their experience managing a pretty significant number of BDR claims right now for a fairly wide range of institutions. Okay, so let's get started. The BDR rulemaking. Let's talk about just a level set real quick. I mean, we're talking about the borrower defense rule. So Congress introduced the borrower defense to repayment concept way back in 1993. It's not new, been around a long time. This is, right now we're dealing with the fourth generation of this rule. At the time, though, the only thing Congress really ever said was, we want the U.S. Department of Education to specify in its regulations which acts or omissions of an institution of higher education a borrower may assert as a defense to repayment of their loan. So in other words, if the department was trying to collect a loan from a borrower formerly at an institution of higher education, could the borrower say, yeah, well, my institution did this or they did that, and I shouldn't have to pay back my loans because they let me down, I didn't get what I bargained for, or I was misled, et cetera. So that Congress said, we want the department to tell us what those things might be that a borrower could point to as a basis for not having to pay back their loan. In response to this directive, the department promulgated a concise borrower defense rule. And by that, I mean pretty brief. In 1994, I'm calling that the 1994 rule for purposes of this presentation, followed by a brief clarifying guidance in 1995. And for a very long time, nothing else happened. There were literally single-digit numbers of borrowers who ever asserted a borrower defense, but then there were some rapid closures of very large proprietary school groups, in particular, Corinthian colleges and ITT Technical Institute. And that, combined with some effort by the then administration and other members of the community, raised some real awareness around this opportunity, and the number of claims skyrocketed from single digits into hundreds of thousands. So the Obama administration carried out a negotiated rulemaking in 2016 to significantly revise and expand this framework, understanding that the 1994 rule really was not sufficient to process all of these claims. And by the way, that's probably true. The 1994 rule, which we'll talk about a little bit later, was quite simplistic in the way that it was conceived. And when the department suddenly had hundreds of thousands of claims to try to get through, it was not very workable. So the result was a complex process for adjudicating claims, sort of a new borrower defense framework that was published on November 1st, 2016, and set to become effective July 1st of 2017. Also, and this is an important note, in January of 2017, on the eve of the Trump administration's inauguration, literally the night before, the Obama administration published a new recovery process. And what I mean by that is, the BDR framework and all this discussion we're having right now about adjudicating claims, that is largely part one of the process by which the department determines whether or not to discharge the student's loans. There's then a secondary question as to whether or not the department would try to recover those amounts that were discharged from the institution of higher education that committed the underlying or alleged act. And that process would be a secondary recovery process. And so when the 2016 rule was promulgated, what I'm calling the 2016 rule here, what we're really talking about is the process for adjudicating the initial claim. It wasn't until January 2017 that the Obama administration published this sort of secondary process and said, well, if there's been a discharge and we want to recover against an institution, which the Department of Education is certainly empowered to do, this is the process by which we would carry that out. Dissatisfied with the 2016 rule, the Trump administration held another negotiated rulemaking in 2018 to revise the bar defense rule yet again. Some of you know I was involved in that negotiated rulemaking and represented institutions, general counsels and compliance officers in institutions of higher education. It published, meaning the department published its own final rule on September 23rd, 2019, the 2019 rule, which took effect July 1st, 2020. The 2019 rule did not significantly impact the recovery process that I was just talking about a moment ago. Its focus, again, was on sort of rethinking and revising the process by which the initial claim was adjudicated between the department and the student. And I say the department and the student because it's important to always keep in mind, you know, this is a debt owed by the student to the department. So really what's being determined is whether or not the department is going to forgive that loan debt that is owed by the student. In a sense, the institution is not a direct party to that contractual relationship between the department and the borrower. But as of course all of you know at institutions, the institution clearly has a stake, right? Because if the department decides to discharge the loan, then they could turn around and try to recover it from the institution of higher education. In 2021, the Biden administration, dissatisfied with the Trump administration's version of the rule, initiated yet another negotiated rulemaking to revise BDR once more. So this is our fourth version, right? We had the 1994 rule, the 2016 rule, the 2019 rule, and now we've got the 2022 rule. So the final rule was published in the Federal Register on November 1st, 2022, and took effect this year, July 1st, 2023. However, in February of 2023, the Career Colleges and Schools of Texas, which is an association of private proprietary schools, challenged the 2022 rule under various theories, as you would expect, that it exceeds authorization under the HEA, arbitrary, capricious, under the Administrative Procedures Act, et cetera. And CCST asked the court to enjoin the enforcement of the new 2022 rule until the court decides on the merits of the case. A federal district court judge in Texas denied this request. However, on appeal, a three-judge Fifth Circuit panel granted a preliminary injunction with respect to the 2022 BDR rule, a nationwide injunction. And as a result, the Department of Education, as of this webinar, is prevented from enforcing the new 2022 bar defense rule, as well as the elements of that 2022 rule that related to closed school loan discharge. And you can see there's a little picture there on the right of that injunction. Okay. This is just a rulemaking timeline. I'm not going to go through all of this again, but I just will note that the slides, all of these little highlighted pieces that you see, these are live links. So when you pull down the webinar slides, if you're interested in pulling any of the underlying source documentation going all the way back to 1994, you can do that. Okay, but before I show you the last two pages of the timeline, let me ask you to take just a moment. We've got our first secret word, and it is rule, not bar defense rule, just rule. So please select the correct word from the list below. I will not tell you which of the letters corresponds to the correct word, but would ask that you please click on that. So the next two slides I'm going to show you, again, I'm just going to click through them, but they're the remainder of that BDR rulemaking timeline. So it consists of 3 slides, and it's got, again, all the different sort of critical moments that have occurred throughout this process from 1994 and the original statutory directive from Congress all the way up through to the litigation, the Fifth Circuit litigation. And some of you I know like to pull those underlying documents and take a good look at them and have them on hand. And if you're responding to bar defense claims, it may be helpful to have that sort of 3-part timeline so you can go to those final rules that were issued or to the litigation, et cetera. Okay, so here's part 2 and there's part 3. Now let's talk about claim volume and the sweet settlement. And I sort of think of this as when you're trying to synthesize where everything is right now, you know, you've really got sort of two big buckets. I mean, one is the rules and where the rules are, and that is in part impacted by the Fifth Circuit. And then the other big bucket is this sweet settlement that's impacting how all this is being managed. So first of all, on claim volume, if you've not already seen this, I highly recommend taking a look at this data set. In response to a FOIA request a couple of years ago, filed by the Legal Defense Fund, the department supplied a list of BDR claims that were pending as of July 31st, 2022. So clearly there could have been many more that have been filed since July 31st, 2022. It's over a year later, but this is still extremely useful because what it shows is that as of that date, there were over 350,000 claims that had been filed. And perhaps even more interesting to some, alleging misconduct on the part of over 4,500 institutions. If you ever pay attention to these kinds of things, you know, there are about 5,900 institutions of higher education presently participating in the federal Title IV program. So perhaps surprising to some, that means that over 75% of Title IV participating institutions have at least a handful of claims. And many of those, according to the spreadsheet, are at 10 or 20 or maybe even less than 10. But it is eye-opening to understand that over about three quarters of institutions of higher education have at least one claim right now. And that was as of last July 31st, 2022. So we've got this significant volume out there, and it's been a huge problem for the U.S. Department of Education going all the way back to the Obama administration. I mentioned earlier, the original 1994 rule was really hard for the department to manage and to try to process and adjudicate claims under that rule. And then you had, the back and forth in 2016 and 2019, which created more complexity. And all the while, the department is trying to figure out, how are we going to manage hundreds of thousands of claims and process them? At one point, the Trump administration attempted to get through some of them. Ultimately, in 2019, a group of borrowers sued the department in the Northern District of California to force the feds to issue decisions on this growing backlog of pending bar defense claims. So at the same time the Trump administration was creating the third version of the bar defense rule, they were also being sued in federal court, and the whole purpose of the lawsuit was to try to accelerate adjudication of existing claims. On November 16th, 2022, the court granted final approval of a settlement reached by the department and the plaintiffs in Sweet versus Cardona, which previously had been Sweet versus DeVos. 3 schools did appeal. The Ninth Circuit and the Supreme Court have denied a stay. Request for stay of implementing this settlement while the appeal is pending. The department filed its brief on August 2nd, 2023. So that is still percolating. But in the meantime, the department's proceeding to process BDR claims under the terms of the Sweet settlement. And as a practical matter, not taking anything away from those institutions that are currently appealing, the fact is, though, that the case may largely be moot, as we don't believe the appellate courts can effectively undo, and by we, I just mean we here at Thompson-Coburn, but we question whether the appellate courts can undo the BDR discharges, even if they rule in favor of the 3 schools, or whether or not the court, even if it rules in favor, would extend anything beyond just those 3 schools. So all of this is to say, you had this settlement. The settlement is currently directing the department's management of the backlog of BDR claims. And there is an appeal out there, but we think it's unlikely to affect the department's direction anytime soon. So let's talk about what the Sweet settlement says, because this is very important for contextualizing the claims that you may be receiving right now as an institution. I would think of it this way. So there are 2 big buckets. You have claims filed before June 22nd, 2022, which is when the initial settlement sort of was proposed. You have claims filed between June 22nd, 2022 and November 15th, 2022. And I guess 3 buckets is another way to think about it. Under the Sweet settlement, there's sort of 2, but then the third bucket would be claims filed after November 15th, 2022. So let's talk about everything that was filed before June 22nd, 2022. So for a borrower who attended, if you look in the Sweet, and this is a live link, if you look in the Sweet settlement, there's a list of schools towards the back in what's called on this Exhibit C. There are a bunch of schools listed, right? So for a borrower who attended a school listed on Exhibit C, the borrower's loans will be discharged in full without adjudication, full stop, right? So if the claim was filed before June 22nd, 2022, and your school is listed on Exhibit C, the understanding is those claims will be discharged completely, even without any adjudication. But for a borrower who did not attend a school listed on Exhibit C, the department will review the application under the 2016 rule. So this is interesting. As part of the settlement, they were able to secure the right to review it under the 2016 rule without regard to when the underlying events may have occurred or the underlying loans may have been issued. But here's the really critical point. The department will not require evidence outside of the written application, require proof of reliance, or apply any statute of limitations to this bucket, right? Instead, the department's going to determine whether the application just states a claim that, if presumed to be true, would assert a valid basis for a bar defense under the applicable regulation. The department has to render decisions within specified periods based on how long the claim has been pending, but no later than July 28, 2025. And if the department does not render a decision within the required period, the borrowers receive full automatic relief. So let's be clear. If the claim was filed before June 22nd, 2022, and the school's on Exhibit C, it's just forgiven, full stop. If the school's not on Exhibit C, then the department is supposed to at least review the application. But, and here's the important point for the schools on the line, there's no obligation that the department notify you about this claim, send you any information related to the claim, or ask for any feedback related to the claim. Because under the settlement, the department does not require evidence outside of the written application, right? Further, theoretically, if the department just sat on all of these applications and did not adjudicate any of them, right, whether your school's on Exhibit C or not, either way, the borrowers receive a full automatic relief as of July 28, 2025, right? So if it's before June 22nd, 2022, I would not expect an institution to ever hear about that claim or receive any opportunity to provide feedback, right? If the claim is filed between June 22nd, 2022 and November 15th, the department is going to review the applications under the 2016 rule again, without regard to when the underlying, loans were issued or anything along those lines. As part of the settlement, they get to review it under the Obama era 2016 rule and issue a decision no later than January 28, 2026. But again, if the department does not render a decision by that date, the borrowers receive full automatic relief. Theoretically, the department could just stop processing claims today, and everything filed before June 22nd, 22, borrowers would get full relief on July 28, 2025. And then everything that was between June 22nd and November 15th, by January 28, 2026, they would all get full relief, right? So it has to make you think, if you are a school, about the incentive the department really has, if you've got a claim filed between June 22nd and November 15th, to take a serious look at that, what you're providing and/or. Now, we're going to talk later. We still think it's very important to respond to these claims. But from the department's perspective, again, they can sit on things. They don't have to complete the adjudication, et cetera. And there's a timeout. There's a point at which the borrowers just get full relief. For claims filed after November 15th of 2022, they're not covered by sweep, which means they would be adjudicated under the prevailing BDR framework at that point in time. So all of this is confirmed on the department's website. There's no guesswork here. I mean, everything I just went over is in the sweep settlement, but lest you have any concern, the department confirms it on its sweep webpage, and that is sweep like the litigation, not the webpage is super cool. They say if the agency doesn't make a decision within the required timeframes, the borrower will receive full relief. If a borrower submitted multiple applications, we'll use the earliest submitted application date, and then they lay out this timetable to the right of your screen. So you can actually see the graduated time frame that they have. So just by way of example, if you look at the first row, if the file was claimed between January 2015 and December 31, 2017, that decision has to be rendered by July 28, 2023. And if the department doesn't get to it, full relief, right? And again, this is for folks who are in that first sort of big grouping where the claim was filed before June 22nd, 2022. But there's sort of a graduated process depending on when the underlying claim was actually filed. With regard to process, the department also confirms on its website that the agency, quote, will review these applications using the 2016 Bar Defense Regulation, but will not require evidence outside of the written application, require proof of reliance, or apply any statute of limitations. So we're talking about claims, again, that were filed before June 22nd, 2022. Rather, the department will determine whether the application states a claim that, if presumed to be true, would assert a valid basis for bar defense under the applicable regulation. So really all they're going to do is evaluate what is on the face of the application and determine if it actually states a valid claim. Borrowers whose applications are approved under the procedures will receive full settlement relief. And check out the second bullet. The department won't deny an application without first providing instructions on what's required for a successful application and giving the borrower the opportunity to resubmit the application. So let's do the math here. If this is a claim that was filed before June 22nd, 2022, all that has to happen is at most, right, the department is going to look at whether it states a claim on its face. And if it's deficient, the department will actually provide instructions on what's required for a successful application, right? So clearly the department's aim, I think, is to try to either just discharge these loans, or if they need to, work with the borrower so that the application states a valid claim on its face so that then they can discharge it. But we do not expect any significant back and forth with institutions. Also, something worth noting, there were some claims that were adjudicated by the Trump administration, but under the sweet settlement, for any borrower who received a notice from the department in December 2019 or later, informing them that their bar defense application was denied, that denial has been voided, and the department will review the application. Okay, so Ed, a couple other points that are really significant. First of all, the department confirmed during the sweep proceedings that providing a class member with full settlement relief under the settlement agreement does not constitute the granting or adjudication of a bar defense pursuant to the bar defense regulations, and therefore provides no basis to the department for initiating a bar defense recoupment proceeding or recovery proceeding against an institution. So if the student filed before June 22nd, right, then the department is acknowledging, you know, we're going to discharge all of these loans, whether the school's on Exhibit C or not, you know, and we might, if the school's not on Exhibit C, have some level of process that involves verifying that the application actually states a valid bar defense claim on it, or a valid bar defense basis on its face. But the department is acknowledging that those discharges and its decision to discharge aren't tantamount to a decision that the institution engaged in wrongdoing. That having been said, there's nothing that would prevent the department from initiating a separate program review or other enforcement action based on those allegations, right? So what we mean by that is if you had 100 bar defense claims prior to June 22nd, and they said, oh, the school is misrepresenting its, you know, graduation rates, and the department discharged all those, and they're saying, okay, well, we can't recover the discharged amounts. But the department could separately initiate a program review and say, well, we've got evidence in our possession that you were misrepresenting, and just start a separate action relating to the misrepresentation and unrelated to the recovery of the bar defense. So we don't think the fact that you have bar defense claims and allegations that precede June 22nd is necessarily, you know, I wouldn't consider that just a clean slate. Let's put it that way. I mean, those could still cause some indigestion. All right. But let's say you've got claims after June 22nd. And that's what a lot of you are likely seeing right now, is claims that were filed with the department after June 22nd. And the department is supposed to adjudicate those claims. Now, you know, if it's between June 22nd and November 15th, they have to do it within a certain time frame, or it times out and the discharges are just granted. But they are supposed to be adjudicating those claims under one of the BDR frameworks, right? So I'm just going to skip through this at a high level because I want to get to the second part of this presentation. But the short of it is there are 4 frameworks in place right now. And I'm just going to show you, you can come back and look at these, right? You've got this 1994 framework, and each one of these slides for each framework breaks down scope, claim standards, time limit for claims, the evidentiary standard, the process, discharge relief, and recovery actions, right? And suffice it to say, as you move through these, right, you'll see that these concepts change, right? The 1994 framework was pretty lean. The Obama era 2016 framework, you had an expansion of claim standards, you had more process, you had the ability for the department to initiate group claims. I think most on sort of the institutional side of the fence would agree that this is a process that is less favorable for institutions, significantly less favorable, I would say. The 2019 framework sort of moved back in the other direction. And was more favorable for institutions in the sense that it narrowed the number of claim standards. It created more process for schools. Consumer advocates, on the other hand, would say in doing so, it also resulted in a loss of process for borrowers, right? And then you've got the 2022 framework, which is more expansive than the Obama era framework. If you just look at that claim standards, you can see there's a significant expansion of claim standards. All the process that was in the Obama era 2016 rule is here again and expanded. This is a far less favorable outcome for schools. I'll just put it that way. It's a far less favorable rule and framework for institutions. But here's what I really want you to focus on. If you've got a claim that's after June 22nd, so it's not just being sort of summarily discharged, but you would expect as a school to get some information from the department, right? Even if it's between the 22nd and November 15th, they're still supposed to be back and forth. Then the question becomes, under what framework will it be managed? Now, Jeff and Scott are going to talk in a minute, and I think this is the critical idea here is no matter what framework you're under, it's critically important that you preserve every argument that you can. In part because, candidly, we're not 100% sure what framework it's going to be under. Some of that's going to be dependent on the Fifth Circuit. And the reason is this. The way the first three versions of this rule worked, and if you look in each one of these, you'll see the 94 rule applies to loans first dispersed prior to July 1st, 2017. 2016 applies to loans dispersed between July 2017 and July 2020. 2019 version applies to loans dispersed on or after July 1st, 2020. So the way those three rules were designed, you the framework applied based on when the underlying loans were dispersed that were in dispute. Because remember, this is all supposedly about a borrower's obligation to repay these loans. The 2022 rule takes a totally different approach. And part of what the department was trying to do is they said, this is getting crazy. You know, we've got all these different frameworks we have to enforce, and it's just too complicated. Instead, what we want to do is we're just going to say anything that applied, or our new 2020 rule rather, applies to any claims pending or filed as of July 1st, 2023, regardless of when the underlying loans were first dispersed. But here's the thing. Almost every borrower defense claim ever filed was pending as of July 1st, 2023. Remember, that's the whole reason for the sweet litigation. The department hasn't been successfully adjudicating all of this stuff. You've got all of these claims going back several years that have been filed and haven't been adjudicated. Well, that means almost everything, if the 2022 rule becomes effective, other than the stuff that's just been totally adjudicated and forgiven, which is just a few sort of big, like for Corinthian and ITT, not most of the stuff that's on that spreadsheet we cited earlier. All of that stuff would just be swept in under the new 2022 rule. So here's the problem. Right now, the 2022 rule is not on the shelf, or I mean, it's on the shelf, but it's paused, right? Which means if your claim is dated after June 22nd of last year, then theoretically, it could be under the 94, 2016, or 2019 rule standards and processes. But if the court at some point reinstates the 2022 rule, all of those will be swept in under the standards of the 2022 rule. Our advice is don't overthink it. Defend this stuff vigorously, preserve every claim that you can make, right? And then, you know, the one exception would be if you were going to specifically argue that whatever was alleged did not constitute a claim, right, under the 2019 rule or the 2016 rule because of when the underlying loans were dispersed, you would need to get real specific, and you would need to know, well, what were the specific standards in 2019? What were the specific standards in 2016? And by the way, some of that is on those prior slides. So you can go back, and then if you really want to get into it, there are citations on the prior slides. I'll just click back here. You can see down in the bottom right-hand corner, we indicate where these frameworks are located. So just theoretically, if you wanted to find, you know, the standards for the 2022 framework, you can see that's at 34 CFR 685-400 through 684-411 in those two spots. That's where you would want to look. Okay, so with all of that having been said, just a summary comment, and then I'm gonna put on my moderator hat. Okay, so first of all, I made this comment a second ago, but this is sort of putting all this together. This is the doing the math slide. So most, maybe all, Trump era adjudications are void. That seems pretty clear. The sweet court took care of that, with the result that pretty much all BDR claims are in play right now, if that makes sense. Very little has actually been adjudicated and forgiven outside of some very large sort of en masse adjudications that were made for particular schools. We expect that all claims filed before June 22nd, 2022 will be discharged in full with really no interaction with schools, right? So I was talking about earlier, the department's indicated that the application need only state a claim, and the department will even be providing instructions on what's required for a successful application. Also recall that the department can simply sit on applications and they ultimately will be discharged in full on July 28, 2025, all of them. So, and that's under suite, and that's not impacted by the Fifth Circuit. So we think that pretty much takes care of everything that was filed before June 22nd. We expect that claims filed between June 22nd and November 15th will be adjudicated with limited or some input from schools, right? And a lot of you are seeing those claims right now. That's what's starting to come out and hit schools. And it does appear to be reaching out to the schools, but the adjudications are under the 2016 rule without regard to when the underlying claim or matter occurred, the loans were issued. And again, keep in mind, the department could just sit on applications in this group and they ultimately will discharge in full. So, you know, I think the department is certainly going to go through the motions. I don't want to be too cynical here, but to the extent this administration's objective is to discharge loans, which by the way is pretty clear. I mean, if you've been paying attention to the headlines, that's a lot of what this administration's policy is about, right? They don't ultimately even have to make decisions on all of these matters. Again, Jeff's going to talk about this, and Scott, we think it's very important for recovery actions, for other reasons, to defend these claims. But in terms of this initial adjudication step, you know, the department can solicit the information from the schools, go through the motions. It doesn't even have to reach a decision, and they can fully discharge everything in this bucket. So it's hard to see, given where their sort of political intentions are right now, why they would work too hard at getting through and adjudicating these claims, particularly if it risks not discharging the loans. Okay, if the department prevails in the Fifth Circuit, it is also unlikely that any BDR claims will ever be adjudicated under the Trump era rule, because almost all remember, the Trump era rule only applies to loans that were issued for the first time after that July 1, 2020 date. And not all of those are pending. And the 2022 rule is going to sweep in everything that was pending as of July 1, 2023. So everything that would have been covered by the Trump era rule would basically get sucked into and covered by the new 2022 rule. And all the old stuff under suite is being adjudicated, to the extent it's being adjudicated, under the 2016 rule, right? But that's if the department prevails in the Fifth Circuit. If they don't, right, and the new rule gets struck down, then that means institutions that are in the adjudication process are going to have to figure out, okay, well, so are we covered by 2019, 2016, or maybe even the oldest 1994, and that's going to depend on when the underlying loans were issued. I know this is a lot to take in. Again, remember, you've got blog posts, you've got a recording of this. You can go back and work through this a little more slowly if you need to. So with all that being said and providing some context, let's do our second secret word, and then we'll get into the moderated section and get some answers from Jeff and Scott. So today's second secret word is suite. Please do click on suite. Again, it is one of the three options on your screen. If you're trying to pick up CLE, please make sure to click on that little radio button there. I don't want you to do what I did and miss the secret word and potentially not get credit. So I see we're getting some people who are submitting. So again, if you're, there we go. I see the numbers at the bottom jumping up. Very good. So once again, especially if you're looking to get CLE credit, make sure to click on that very top button. All right. I'm going to wait just another second to give as many of you as possible a chance to click on that second secret word. Okay, so let's keep going. Hopefully you got it in there. Okay, managing BDR claims. I'm putting on my moderator hat, and I'm Jeff and Scott going to turn to you guys. Thank you for being patient as I went through all of that. Deeply appreciated. You all are managing lots and lots and lots of these. Let me start by asking, what kinds of institutions are receiving these complaints now, maybe as opposed to a year ago? How's it changed?
Thanks, Aaron. This is Scott. I'll take this one. I appreciate the early softball. But basically, about a year ago, we saw a lot of proprietary institutions getting these complaints almost exclusively with large complaint counts. That was kind of the population that we saw. As of now, it's completely changed. So it really is less dependent on proprietary versus nonprofit versus public. We're seeing these claims across higher ed, a lot of 5 to 10s, and really in that kind of third bucket that Aaron, you spoke about with suite, the department's clearing the deck and trying to get presumably allow these out because they are now time limited.
Scott, are you seeing most of the claims, do they seem to be dated after June 22nd?
Yes, they are all, or almost all, in that June 22nd to November 15th bucket.
Got it. So it seems like the department is, certainly not looking for institutional input on anything before June 22nd, but it does seem like understanding they've got a time limitation for the claims filed between June 22 and November 15th. That's really the focus at that point. Is that fair?
Exactly right. Yes.
Okay. So now on this slide, I've got a real compound question. So let's say my institution's received a complaint, and I'm going to throw this out, Jeff, to you and to Scott as well. Should the institution respond? Who from the institution should be involved in investigating the claim? And what kinds of documentation should be gathered and included in the response?
Hi, this is Jeff. I'll answer your first question. On whether or not you should respond, it's really a cost-benefit analysis. I mean, it's going to involve some costs and some time on your part to prepare a quality response to the department. That being said, it's pretty much guaranteed that if you choose not to respond, the department is going to grant the student's BDR application and discharge their loans. In fact, it's part of the 2022 rule, specifically right in there, that says if an institution, do not respond within 90 days, the department will presume that you do not contest the borrower defense to repayment claim. I know the rule is on stay right now, but that's going to be the attitude of the department with or without this rule. They figure if you don't care, we don't care. We're going to discharge the loan. Secondly, you ought to respond too, if nothing else, to deter the department from pursuing any recoupment action against you. Assuming the department is going to grant the discharge, if they see that you, a school, are not going to fight at the first stage, they may think, well, this institution will roll over and won't fight us when we, the department, come after you to try to recoup the discharged loans. So I think there's a second benefit to responding, and that's also to deter the department from coming after you. And it also helps too if you work now, while the stuff hopefully is as fresh as it's ever going to be, is that you get your stuff together, your documents, your facts, your evidence. You get it together now. If the department does decide to pursue a recoupment against you 2, 3, 4 years down the road, you'll already have your evidence ready to go and mustered to push back against the department if they try to come after you.
Yeah, Jeff, great advice. And the other thing that occurs to me too is even outside the bar defense discharge proceeding, I mean, if you've got 10 or 15 students who are alleging that you misrepresented on some matter, sort of going back to what I mentioned earlier, I mean, there's nothing stopping the department, totally independent of the bar defense sort of context, from initiating a program review or an audit or an investigation out of the enforcement unit. And if you've not responded to these initial claims and they've just walked into an adjudication, now you're already kind of behind the 8 ball, as they say, because the department's got evidence asserting misconduct and you've not responded to that evidence at all. Is that fair?
I think that is fair. And if you don't respond to and you start getting a lot of loans discharged by your students, that also opens you to potential lawsuits by plaintiffs' lawyers throughout the country. You might think, wow, this institution is just going to roll over. This will be easy pickings.
Lawyers. Yep, attorney generals. The last thing I'll mention too, we're not really talking about financial responsibility here, but folks should be aware that there are places in the regulations where, we've got all these new rules that have been coming out, where a high number of bar defense claims, even not adjudicated, just the presence of claims, can sort of have what I'll call collateral regulatory damage. And that includes for financial responsibility. So one of the new triggers that this administration is proposing is if you have an institution that's got a high number of BDR claims that have been filed, that represents a potential financial impact to the institution. And they could use that as a jumping off point to require some sort of surety or take other action under the, based on the argument that the BDR claims represent a potential threat to your financial responsibility. So just so many important reasons to respond, even if it seems likely that the department's going to, discharge the specific loans. How about the second question, Jeff? Scott, who from our institution should be involved in investigating the claim?
Yeah, so hopefully we've convinced everyone that response is a good idea. We should spend some time. It's worth worth the benefit to do it. But who shouldn't be involved really depends on the claim, dictated by the allegations the student makes. So the first thing we'd recommend is just kind of figure out who's on first, who's leading the investigation from your institution, be it counsel, compliance, financial aid, kind of who's the best person to kind of be that quarterback and figure out what we need to respond, what is responsive, what documents we need, and go from there. And then the claims we see really fall into a few buckets. So there's a lot of claims dealing with admissions, promises made about the admissions process, may or may not kind of have a specific person. So if that's the case, then obviously your admission staff, presumably or hopefully someone there remembers that time period, but admissions can be involved. Financial aid, if it's determining what awards were given, scholarships, or claims that you weren't told about certain financial loans, financial aid should be involved. Academics, a lot of promises regarding transfer of credits, employability. These could be an academic piece, and student catalogs and handbooks can help out, as well as career services. You also want to make sure you include someone that has good knowledge of the institution's policies to kind of provide evidence of what may or may not have been the policy at the time of the claim, as well as IT staff, because you might have to go back and look through emails and kind of do a little archaeological dig to figure it out. So depending on the claim, just kind of whoever makes sense to the institution, whoever would be that responsible person to be able to gather the documents, that's who should be on your borrower defense team. And I'll turn it over to Jeff and ask the third question. What kind of documentation, now that we have our team together, what should be included in the response?
Sure. As with who you interview and talk to about a student's complaint, the documentation that you're going to gather is going to be based on what the student is alleging. So, for instance, if the student's complaining that you promised me a job or you told me my credits were going to transfer, hopefully you've got some documents such as a student catalog or a handbook. Perhaps you have an enrollment agreement. Perhaps you have other disclosures that were signed or given to the student saying, no, there is no promise of employment. Your credits may not transfer, or other statements that directly contradict the student's allegations. So you're going to be looking at handbooks, catalogs, enrollment agreements. You may have to look at financial records if they're complaining that the aid you gave me was a loan, whereas you told me it wasn't going to be a loan. Well, if there's a loan, there's probably loan documents that were signed. There's loan counseling acknowledged by the student. So hopefully you have some of those records available. Some of the questions we have, I've seen, which are very good questions. What if I don't have the documents any longer? That's a big problem because a lot of these complaints by students come from students who attended your institution a long, long time ago. In some cases, we've seen complaints from 10, 20, 30 years ago. So what are you going to do if you don't have the records? Well, obviously, you're still going to deny that you lied or deceived the student. But the best thing you may be able to come up with is hopefully you still have some of your form documents, maybe your form agreements or disclosures or catalogs. Use those and say under our process, standard process, at the time the student would have seen this, would have completed it, would have signed it. And that's pretty much the best you're going to be able to do. But the more documentation you have, the better, because the student complaints you're getting, virtually none of them have any substantiating documentation for their claims and the allegations. We as the schools typically do have a lot of documents that directly refute what the students are saying.
Yeah, Jeff, and I'll add too about that last, that last piece about documentation. Sometimes we find in our responses helpful to point to some of the department's own policies. The Student Privacy Office has information regarding how long documents should be kept. So in addition to kind of saying we followed our record destruction policy, we don't have a specific thing, provide the documents that Jeff alluded to, and kind of throw the department's language back in their face, or at least point out to them that we don't have documents because this is what you recommended. This is the best practice.
I'll also add, this is Aaron, I mean, depending on how all of this plays out, whether the new rule is in place or not, there are versions of this rule that include statutes and limitations, both on when a borrower can bring a claim and on when the department can recover. And again, that changes from one version of the rule to the next. I mean, the current administration, it's clear, and under the proposed rule, that there really is no statute of limitation on when a borrower can bring a claim. There is still conceivably some ability to to argue that if you were ended up in a recovery proceeding, that the department no longer has the ability to recover. But the one thing you should be aware of is under both the 2016 and the 2022 versions of the rules, the department has great ability to, even after something has been adjudicated, potentially reopen it if there's new evidence, things like that. So there's a lot of flexibility under the Obama and Biden versions of this rule to reopen processes or rethink processes. That having been said, again, it is conceivable. I mean, if you were particularly facing a recovery proceeding, you know, you would want to sit down, either you or with your outside advisors, and look, you know, pinpoint exactly when these underlying loans were issued, what version of this rule is applying, particularly if the Fifth Circuit ends up striking down the 2022 rule and determining whether there were any arguments around statute of limitations. But to be sure, the general attitude of the current administration is to try to entertain every possible complaint. All right. My institution has received a complaint. Oh, sorry. I think I went in the wrong direction there. All right, here we go. Sorry. Okay, so what should I look for in the student's complaint? And then I think we've got some slides here, so I'll go to the first one.
Sure, this is Jeff. Take this. This is just, I mean, you've probably seen this in all the borrower defense applications you've been receiving. These are bullet points that the department itself says cannot substantiate a borrower defense discharge. So if the allegations fall within these categories, I think it's important you put in your response and say, hey, per your own application, this doesn't cut it. So you can't grant a discharge to this student. So you have stuff like that. And there's other stuff in the applications, and I'll touch upon these really quickly due to the interest of time, that you can use against the student. It's like you use the student's own words against them. Now, note, some of these may or may not be that relevant depending on what framework you're in. But I think in responding, you ought to put everything out there, throw it all out there and back to the department to justify every reason why you think the department should not discharge the loan. So we've got stuff like, you can see people and the students will answer questions. They're asked, well, how did you rely, or did you rely on these statements or these promises? And a lot of times the students check no, which you think, well, that's not very smart, is it, on their part? You think they at least be, figure out they ought to check the box yes, but they don't. They check no. So I think we use that to our advantage. They might also say there's no financial harm when asked, what is the loss to us? A lot of times there'll be a $0 amount there. Again, that may not really apply under which framework it's at issue, but it doesn't hurt to put it in there. Statute of limitations issues. Now, the department may not apply a statute of limitations in determining whether or not to discharge a loan, but there is a statute of limitations on whether it can come after you to recoup. And I think it may be important to show to the department and say, wait a minute, this student, he graduated, many years ago. He says in here, I learned the information provided to me by my school is inaccurate, in this case, over 8 years ago. So why are we waiting now? Statute of limitation bars this claim. Another good point you might want to raise. If somebody complains and says, well, you promised me a job. Well, wait, student may say, well, I never actively pursued a job. So how can we be at fault, the school? Obviously, we didn't promise a job, but assuming we did, well, the student didn't even try to get a job. So they shouldn't get a loan discharge. So you have that. Also, if they were fired, I've seen applications where the student admits, yeah, I had a job in my field, but then I got fired. So how is that the school's fault if the student got fired? So you have a lot of that in the application that can be of use, and you might as well use it because the student's not providing any evidence, and anything the student says that can be used against him, I would definitely do so.
And I'll just to be clear, some of you may go online and you'll see that the department, this administration has a new application, but the applications that were filled out by the students who've filed those claims and that you're now fielding likely were the Trump era applications that included these questions. So to Jeff's point, it's very important to look through, and if there are facts like that the student has conceded or indicated on their application, those are the types of things, obviously, Jeff makes a great point that you want to raise. The other thing is, if the Fifth Circuit strikes down the new rule, you may actually be managing the claim, or the department may be managing the claim under the Trump era rule, where financial harm and things of that nature are part of the framework that for the adjudication. So it's really important to review the application carefully, and I'll sort of say leverage important factual points that are actually in those applications. So I understand I should provide factual responses to the claims. Is there anything else I should be including in the response?
Yeah, this is Scott. I'll grab this one. And I think we went through a lot of these already. I'll go through them quick. First thing to mention, we think factual responses, factual refutations to the BDR claim are going to provide your most powerful evidence for the department official to consider. Presumably, they're not going to take much time to look at this, so kind of strong factual arguments kind of may be your best way to go. We strongly recommend that institutions review the allegations, methodically address each one by one, restating it verbatim, and then denying it and kind of providing affirmative reasoning, documentation, et cetera, in your response. So factual responses hopefully are a given. Hopefully you guys have good evidence to go. In addition, a lot of the things that Jeff talked about in the previous slides, so go through it quickly. Conduct that can't meet the standards, kind of based on the application itself. A lack of reliance by the student, lack of harm shown by the student, statute of limitations arguments, lack of the student kind of employment piece. Those are all things that would be helpful defenses to include as well to kind of prove your points. In addition, just wanted to, a lot of applications we've seen kind of really don't submit a complete application. There's no descriptions, there's no people reference, there's no when, why, how, all the et cetera responses, really not a complete application. Pointing that out to the department we think is helpful, and just explaining that the institution really is prejudiced to try and respond to a complaint where they're guessing at what the institution or what the student is alleging. We really have bits and pieces. That's not a grounds for a true bar defense claims. Also, if the student admits promises or conduct weren't part of their enrollment decision, that reliance piece would be helpful. And also, we also recommend to the extent the school is comfortable, and we certainly recognize this is an aggressive position, but challenging the entire process, the fairness of it, due process, the constitutionality of it. Again, not because the department will be persuaded when reading this, but to potentially dissuade the department from moving on, or if a recovery process is ever initiated, preserving these kind of larger legal arguments.
Yeah, you know, I mean, there are always the harder arguments to make, but there's going to be a lot of low-hanging fruit. And as my dad used to say, low-hanging fruit is still fruit. So please make sure that you're making all the important arguments. We've seen a lot of questions popping up, you know, well, what if the student wasn't really a student? What if they didn't get any Title IV loans? You know, what if they've conceded that we didn't do anything wrong and they just want a discharge? I would point all of that out. I would not leave anything on the table, or however you want to think about it. You know, whatever metaphor suits you. We think it is important to be aggressive about shutting these down, and if there's an obvious reason that it's, you know, should not be that the loan should not be discharged, you should point that out. All right, by the way, one other point, we've got a little time. I know we're coming on the top of the hour, but Jeff, Scott, and I are able to stay on for 10-15 minutes after, so we're going to keep going because we want to make sure to get this important information out, and we want to try to hit a few questions as well. Why and to what extent does it matter which framework applies? You know, I'll actually take this one, and I think we've talked about this, but just to recap, if the 2022 rule sticks, then it probably won't matter that much. There is a retroactivity issue here, and the department has indicated that in some cases, if, for example, if you had loans that were dispersed on July 1st, 2021, so they're clearly under the Trump rule during a period of time for which a breach of contract was not a claim, and the 2022 rule becomes effective. What this administration has said is we would still adjudicate that claim and allow a breach of contract as a basis, but we will not pursue recovery if under the rule that was in play at the time the alleged misconduct took place, it would not have been a basis for a bar defense claim. That's a mouthful, but there is some of that. But the very short answer is it's possible the 2022 rule might not stick, in which case it's going to be important to understand which one of these frameworks you're under, because that may dictate whether or not the alleged misconduct actually is a basis for a claim, because the claim standards have changed from one administration to the next. Okay. Gentlemen, back to you. How do we address vague or unsubstantiated claims?
I'll grab this one, Aaron, and I think you actually hit on it in your other point. This is the low-hanging fruit is still fruit. So if it is a vague claim, tell the department that they claim. Just hammer it. Make sure that you discuss what's there, and particularly what's not there. How that kind of the vagueness, the insubstantiation doesn't lead to an actual full complaint, and really make sure you're not leaving, not just kind of not addressing an argument because it is so vague or because it really doesn't have anything. Point it out that this is not a substantiated claim. This is not something the department should even entertain for potential recovery.
All right. So let's say a school's received some complaints that are not very well done. First of all, is this typical? And secondly, again, how do you manage a confusing or not well-written complaint?
Yeah, this is Jeff. I'll take this one. Based on my experience in the last few years, it's the rule, not the exception, that a typical BDR complaint will be very poorly written, often highly illiterate in what the allegations are. And for example, I had one that read this morning where the student complained that they had to take prerequisite courses. That was the basis of their complaint. There were prerequisite courses. And I had to think, well, isn't that the whole point of the course, the program of study? All the courses pretty much are prerequisites. That's what you're there for. But anyway, you will get students who make allegations that make absolutely no sense. And sometimes the allegations will contradict. They'll say one thing one place and another place. For example, I saw one recently where the student said, oh, I didn't know I was going to have loans. And then later on, they basically admit that they knew they had loans and that there really was no issue with the loans. So you want to kind of use those allegations against them. And I would go back in your response to the department and say, the allegations don't make any sense. The more you can hammer upon that theme, the student should have less and less credibility with the department. And remember that the students are typically submitting applications with zero supporting documentation, no evidence other than the student completing the application, which, by the way, a lot of times is basically checking boxes where they've been led to make allegations against the schools. It's not like an open-ended query, what did the school do wrong? The department is guiding students to make certain kinds of allegations against the schools. Yes, the department is asking students to then supplement, but when the students are actually have to put it in their own words and supplement the check the box allegations, they can't do so. And what they're saying doesn't make sense. And I think you need to go back to the department and point that out.
Yeah, and I'll, just to be clear, because I want to, I don't know if balance is the right word, but we certainly know, and I'm sure all of the institutions on the line know, that sometimes institutions do things wrong, and intentionally or unintentionally, and there, without question, will on occasion be bar defense claims that are quite valid, and where students, list a valid claim and explain their reasons. But to Jeff's point, we see a very high percentage of these claims that are not only, setting aside whether they're well written, they don't state a valid claim on the basis of, it's, the types of things some people are putting in the box, or that Jeff has already indicated, I didn't know there were going to be prerequisite courses, or, I didn't like my teacher, or things that just aren't even remotely near any valid claim. And we think it's extremely important to address those. Okay, if the department decides to discharge our students' loans, is my institution required to pay back the amount discharged?
I'll grab that one, Aaron. And short answer is, I think as you discussed in the earlier presentation, it's a bifurcated process. So the piece that we're going through, the student's complaint, the department going to the school's response, this initial kind of part A, part one of the process, that is just between the student and the Department of Education, and it's the department's decision about whether they want to forgive those loans, the amount they want to forgive them in, and the school kind of input ends at the response you're going to provide. For the department to kind of come after a particular school to repay amounts discharged, that have to kind of go under that second part of the process, the recoupment, the recovery process. Different frameworks, as Aaron kind of put in the slides, are under different subparts, subpart G or subpart H, different presumptions, different favorability, kind of for or against institutions. Subpart G is a little more favorable to institutions, subpart H is not, and some of the presumptions. But that process has due process for the institution. There's an institutional involvement. It's before an arbiter. There's opportunity to present evidence, and that kind of will come at a much later time. So it's not necessarily you would have to repay it if the department makes that decision, but it is a possibility.
Yeah, and I'll just add, right now, I get this question fairly regularly, which is, well, how are these recovery proceedings going? How many are there out there? How's the department proceeding? To my knowledge, there have been virtually no recovery proceedings. Keep in mind, I mean, the whole point of the sweet litigation is the department has not even been successfully getting through the first step adjudication. So as of today, we don't have any sort of empirical data set that we can look at, involving months or years worth of these recovery proceedings. In fact, there's really only one that has been sort of publicly discussed. I think recently the department, in fact, maybe today, just announced a second one. And both of the recovery proceedings that, have really garnered any sort of serious attention involve, hundreds of bar defense claims against a single institution. So you can understand why it's in the department's best interest, or not best interest, but why the department is interested in pursuing recovery actions where they've got, huge bunches of bar defense claims that are alleging a particular issue against a particular school, because that's sort of one big proceeding. But, to date, we've not seen lots of small recovery processes. In fact, that leads to the next question. So is the department going to pursue recovery for 5 to 10 loans? What do you guys think?
This is Jeff. I think it's highly unlikely. I mean, Aaron, you touched upon the very few recovery actions to date. We had the one from many months ago initiated against DeVry. Yesterday, the department announced is going after the University of Phoenix for $37 million. So obviously, it looks like at this point, the department's only going to go after big schools involving lots of money where there's potential big recovery, and they can make a big splash by doing so. If the department starts going after every school for every loan that it discharges, schools presumably are going to fight back. They're going to file appeals, as is their right. The Office of Hearings and Appeals, which only has a very limited number of administrative law judges who are already swamped with handling appeals and program reviews and other matters, they're going to swamp them even further with appeals from recoupment actions on borrow or discharge. So I think it's highly unlikely the department's going to come after. Now, it doesn't mean they can't. I mean, they could. I mean, who knows? But I think typically the department's probably only going to come after schools where there's a big volume, where it's a similar type of allegation. They can hopefully try to defend and proceed in one case, and involving an awful lot of money, not just, $1,000, $10,000 here and there, but millions, if not tens of millions of dollars.
Thank you, sir. Very quickly, and I'm going to get to a couple of questions. I do want to note, we now have a single place where we're putting all of our resources. It's our resource page, and we've got all our webinars are there, all our white papers, our blogs, all of those kinds of things. We'd be delighted for you guys to check it out. It's all free, and we think, useful content. It's not advertising material. We typically put together things that we think are going to be helpful to schools. We do have the blog, and you can see here we recently wrote about this issue, and some of the things, if for some reason you can't get the slides that we've discussed and referenced today, are located in that blog and linked. We have some white papers. If you'll look in the middle, there's the suggested protocols for responding to individual bar defense claims. So if you go to our resources page, or if you go to that blog, we've put together a 2-page white paper that includes a lot of these ideas and gives some specific advice to institutions, things they may want to consider when responding to claims. And finally, just a disclaimer, we're not your attorneys unless we're your attorneys. Hey, Jeff, here's the first question I want to ask you. We just have 4 or 5 minutes here, but I do want to try to get to it. One of the questions, and I think something that comes up often, is around extensions, Jeff and Scott. And, I guess the question is, what have you seen in the past with regard to extensions? You think how do you think the department will respond differently if we're talking about, 400 claims versus 3 claims, that kind of thing?
Yeah, well, on extensions, the department, in my experience, has been willing to accommodate, long as you're upfront with the department. You ask for an extension. You don't wait to the last second for an extension. You tell them, look, I've got all these claims. It's going to take me some time to get it. In my experience, the department has been accommodating. long as you maintain communication with the department, let them know you need the additional time. But you got to be reasonable. They're not going to give you a year to an extra year to respond. But if you need another month or two, they typically will play ball with you on that.
Yeah, and I'll mention too, Jeff, I think that's certainly the case for the big kind of many complaints. I've seen a couple examples recently of schools with just a handful where the department kind of has said the 60 days is sufficient, has been less willing to give extensions. So if you need to seek an extension for a few amount of claims, I think just making sure your reasoning is solid and up there and something the department would grant.
Couple more questions for you. One, is there a specific format that schools should use in responding to bar defense claims?
Well, I don't think there's one necessarily. Oh, go ahead, Scott. Go ahead.
No, I was going to say, yes, I agree. There's no certain format. We have our preferred one, but it's up to the individual institutions. The only thing that I would just say, and Jeff, I'm curious your thoughts as well, is just making sure that you really kind of make it easy for the person reviewing to kind of see the allegations. The way we set it up is state the allegation, state the denial, kind of make it short and sweet. Assume that the person reviewing it's not going to take too long, and just kind of really kind of hammer the factual and legal points that we discussed that you might have as best you can.
Yeah, and another thing I've seen too, which I think is a great idea in a response, is if you can, you probably submit documentation along with your response, but to the extent that you could like take a screenshot from another document and insert it within your response so that the Department of Education reviewer can just look at it without having to go flip through other documents. I think that's a nice touch if you can do it. I don't think it's critical, but it is a nice touch for your response.
Yeah, I agree. Just as a general matter, we do lots and lots and lots of filings with regulatory entities, the department and others. And one of my rules of thumb is I never want it to be any harder for the agency than it has to be, right? I don't want them having to flip around. I don't want them getting frustrated. The easier I can make that for them to agree with me, the better. One of the questions somebody had is about whether or not you'll get a decision from the department back. On all of these frameworks contemplate providing, or at least 2016, 2019, and 2022, all contemplate providing the institution with a response. But keep in mind, the complaints that are filed before June 22nd are really being managed under the settlement, the sweet settlement, and not in accordance with the regulations, in a sense, right? So my expectation, candidly, is that there won't be any decision issued to the university or an institution if the claim is pre-June 22nd, unless they're initiating a recovery proceeding, in which case I think they would have to supply you with information. Although, as noted, they're not supposed to initiate a recovery proceeding for any of the complaints, the pre-22 complaints that are discharged under sweep. Let's see, one more question, trying to squeeze in everything that we can. We talked about statute of limitations. Let's see, challenging claims. Oh, here's an interesting one. We'll end on this one. What does a school do if the student mentions zero financial harm on their application? Jeff, you sort of spoke to this, or you did speak to it.
Well, we did. And you got to recall, too, that you may, depending on what BDR framework you're under, there may be no requirement that the student claim or show any financial harm. And the department may say, well, it's presumed there's financial harm because they took out the loan to go to your school based on a misrepresentation. But using that little blurb from a student application where it says $0 for financial harm, I think is helpful. If even regardless of which framework you're in, because it shows, hey, wait a minute, the student doesn't even think they were harmed here. So use it against the student when you can.
Yeah, agree. I think we're going to have to conclude here. If you want to reach out, if you need help with BDR or you have questions, please feel free to reach out to Scott and Jeff in particular, who are leading up, as I mentioned, our BDR response team. We're happy to help folks if that is something that you're looking for. Otherwise, please do fill out the post webinar survey. We're always grateful. And just in general, we're grateful to everyone who tunes in and is part of this sort of webinar series and this community. Thank you all. Hope you have a great afternoon, and we'll see you next time.